the provisions of section 115 of the Code of Civil Procedure. To begin with, I would read to you the provisions of section 115, and then I would also like to decipher the essential ingredients of this provision. And then we will continue the journey of understanding how the judicial opinions have understood the ingredients of this provision of law. Section 115 reads thus, it is revision. Says the High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in the exercise of its jurisdiction illegally, or with material irregularity, the High Court may make such order in the case as it thinks fit, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. High Court shall not, under this section, vary or a revision shall not operate as a stay of suit or other proceeding before the court, except where such suit or other proceeding is stayed by the High Court. I will stop here. The whole of the provision can be reread by each of you. It is very essential for all of us to know that the Code of Civil Procedure 1908 is also amended by various state high courts. For example, for section 115 of the Code of Civil Procedure, we have an amendment of the Madhya Pradesh High Court. We have an amendment of the Uttar Pradesh High Court. We have an amendment of the Orissa High Court. Essentially, the amendments made to few of these states is vesting of the power of the revision, not only with the High Court, but also with the District Court or any superior court to exercise jurisdiction of revision over the orders made by the subordinate courts. The power to exercise revision is conferred on the district judges based upon the valuation of the suit or the proceeding, and the High Court based upon the said valuation. And therefore, there have been a certain cases where it was required to opine whether a revision which is exercised by a district court is still amenable to another revision by the High Court or not. Nonetheless, excepting for those few high courts where there is a different amendment, the provisions of section 115 applicable to the whole of the country would, including those three courts, require these elements to be fulfilled. These I have called them as prerequisites. We have read 115. The most essential element of 115 are these. One is, it should be a court subordinate to High Court. That is, the order or the proceeding which is challenged before the superior court in the revision jurisdiction, the order or the proceeding should have been by a court subordinate to the High Court. I will also elaborate as to what is this court subordinate to High Court a little later. Then the next element is that it has to be a case decided. That is, it's not just any proceeding or any order that can be challenged in a revision, but such order or proceeding should amount to a case decided by the court subordinate to the High Court. And essentially, a revision lies when no appeal lies against such order to any appellate authority. These are the prerequisites to say as to when a revision can be thought of by the parties or the advocates. Now, what are the essential grounds on which the revision can be exercised so far as Section 115 of the Code of Civil Procedure is concerned? These are the essential grounds, I may say. One is where the court has exercised jurisdiction not vested in it. Second is when the court has failed to exercise jurisdiction so vested in it. Or thirdly, when the court has acted illegally or with material irregularity. So these are the three essential grounds. Now there is a proviso also to this, which again makes the requirement essential to maintain a revision. And that proviso is that a revision would not lie unless the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or proceeding. So this proviso is a proviso which is added by the amendment to the Code of Civil Procedure by amendment with effect from 1/7/2002. Now this proviso, essentially we can understand the spirit behind this proviso. It is essentially to ensure that not every small order which doesn't affect the rights or obligations of parties to the suit should not be subjected to a revision before the Superior Court or the High Court. And therefore, only such orders which are having the effect of finally disposing of a suit or a proceeding can be subject matter of revision, apart from the other orders where there is an error of jurisdiction. Let us start with this. What is a court subordinate to High Court? Just some time ago, we were discussing with the organizer that there is a possibility of evolving law. And that's probably one of the tasks of the courts while interpreting the provisions of law. And that makes us very, it becomes difficult for advocates to understand as to how we can decide as to what remedy we can actually avail of. But then it should be our endeavor before the courts to assist the court in ensuring that the courts are given the appropriate material to decide about the correct interpretation of law. Now, this is what I have found out, subject to what you all may further make research upon. See, as you all know, that the courts are established not only under the Code of Civil Procedure, that is under the relevant Civil Courts Act of particular states, but there are courts established as tribunals and special courts under various special enactments and specific enactments. Now, unless such a court established or a tribunal established under a special enactment is also a court subordinate to the High Court under the Code of Civil Procedure, a revision will not lie under the provisions of 115 of the Code of Civil Procedure. This has to be understood very meticulously because I have at least come across 3 judgments of 2 different high courts, of 3 different high courts, which have taken a different opinion, have expressed a different opinion about whether a particular tribunal or a special court is a court subordinate to the High Court under Section 115 of the Code of Civil Procedure or not. I may give you an example of the courts which decide the motor vehicles accident claims. They are essentially tribunals established under the Motor Vehicles Act. Now, the Honorable High Court of Maharashtra, in a case reported in 1997 ACJ, page number 372, in the case of Gurucharan Singh, Hardayal Singh Sethi versus Narari Lakshman Shinde, after referring to various provisions of law and other judgments of various courts and Supreme Court, has held that since the tribunal established under the Motor Vehicles Act, by virtue of the rules framed thereunder, follow the procedures applicable to the civil courts under the Code of Civil Procedure, the power of revision can be exercised by the High Court under Section 115 of the Code of Civil Procedure. So the line of thinking, rather the question there was whether a revision would lie or a petition under Article 227 of the Constitution of India would lie. These were the questions there. While answering the other questions also, and those other questions are subsequently referred to a larger bench of the Honorable High Court of Maharashtra. But then this judgment held that yes, the tribunal under the Motor Vehicles Act is amenable to the revisional jurisdiction under the provisions of 115 of the Code of Civil Procedure. Now, the next of the decision is a larger bench decision, a judgment of 3 learned judges of the High Court of Karnataka, where they found that there was a conflict and therefore the question was referred to the larger bench, and the larger bench has decided the issue in the case of Union of India versus Mysore Paper Mills, which is reported in AIR 2004 Karnataka page 1. And there the larger bench of the Honorable High Court of Karnataka holds that tribunals under the Motor Vehicles Act or under the Railways Claims Tribunal Act, there are tribunals under the Education Act. So such tribunals are not courts subordinate to the High Court for the purposes of Section 115 of the Code of Civil Procedure. Now, the reasoning is this. The court took note of the fact that the legislature intended that certain kind of cases should be decided by special courts or specially established tribunals and should be taken out of the purview of the normal civil courts. That was the purpose of establishing these tribunals and special courts under various enactments. If that was the purpose, then to bring those tribunals under the revisional jurisdiction of the High Court under Section 115 would be doing injustice to the very purpose of the legislative, I can say the legislative intent itself. And therefore, the Honorable High Court of Karnataka held that these tribunals are not amenable to revision under 115. Similarly, the Honorable Rajasthan High Court, in a recent decision in the case of Manish Kumar Mishra versus Badribai and others, has held, while deciding the question as to whether a miscellaneous appeal, that is, an appeal under the provisions of Order 43 of the Code of Civil Procedure would lie as against certain orders passed by the tribunal established under the Motor Vehicles Act. While holding that such miscellaneous appeals would not lie, the Rajasthan High Court holds that for the purposes of the provisions of Section 115, the tribunals are not courts subordinate to the High Court. And therefore, ultimately, it is held that for such purposes, it is only Article 227 which can be invoked. Now, my dear friends, all advocates here and students of law who would become advocates one day, my earnest request is that the law should also be consistent. The interpretation of law should be made in such a manner, keeping in view not only that the true legislative intent should be manifested by such interpretation, but also that the law should be consistent, and therefore it should be our endeavor to ensure that there are no conflicting opinions of courts. Nonetheless, what is important for the purpose of our topic, our discussion today, is that if we are deciding to either file a revision or not to file a revision while challenging an order or a proceeding of a trial court or a court subordinate to the High Court, then it is essential to keep in mind as to whether that order passed by the court, that court is a court subordinate to the High Court under Section 115 of the Code of Civil Procedure or not. For which purposes you may read Section 3 of the Code of Civil Procedure, Section 9 of the Code of Civil Procedure, and the other special enactments to understand whether this court would be a court subordinate or not. But this is one of the vital aspects which you have to keep in mind. The second ingredient or the prerequisite to understand the provisions of Section 115 of CPC, as I told you earlier, is that when we want to file a revision challenging any order or a proceeding, such order or proceeding must amount to a case decided. These are the words employed in the provision itself. And therefore, unless the proceeding or the order amounts to a case decided, there is no question of challenging that in a revision. Therefore, I may refer to only one or two decisions to understand how the Honorable Supreme Court has explained what is a case decided. In the case of Madhu Limaya versus State of Maharashtra, reported in 1977, Volume 4 SCC, page 551, the Supreme Court explains that if the court adjudicates for the purposes of the suit some right or obligation of the parties in controversy, that is, the adjudication may not be final, the adjudication will still not be purely or simply interlocutory or interim in nature. So the character of that order will show that there is some adjudication or some right or obligation of a party, or the right of a party is affected by such order. And therefore, though it is not final, since it affects or adjudicates the right or obligation of a party, such orders would amount to case decided. However, there have been instances where we have seen where an adjournment is sought for and is granted or not granted, and such an order was also subjected to a challenge before the High Court in a revision under Section 115. So this all such the experience of the legislature has been that the provisions have been understood sometimes misunderstood. And to clarify such misunderstandings, such opinions are taken note of and appropriate amendments are carried out to the very provision itself. So this is the opinion of the Honorable Supreme Court, which is also the opinion reiterated from an earlier opinion in the case of Baldev Das versus Filmistan Distributors, which is a case reported in AIR 1970, Supreme Court, page 406, where also the Honorable Supreme Court holds that yes, it may be a case of adjudication at an interim stage, which may not be final, yet it affects the rights and obligations of the parties, and therefore a revision lies. As in the case of Madhu Limaya versus State of Maharashtra, the court pointed out that a pure point of law, like maintainability of a suit, which can be decided under Order 14, Rule 2 of CPC, without reference to any other facts of the case, such order affects the right of the party to pursue the remedy of filing the suit itself. And therefore, a revision would lie, because such order, though not final, will amount to a case decided. So this is the second ingredient, which is essential to be taken note of by all advocates to know whether a particular proceeding or order can be subject matter of a revision or not. There are few finer aspects of the revision. These are things which we all need to keep into account. I have tried to point out these things because we would normally see that such points are canvassed before the courts, but then we would not be readily having such judgments at hand. So to lay easily your hands on such judgments, I am just trying to help you out. If I am not perfect or correct in using these judgments, I request the discretion of the audience to also make more research. Now, one of the points that has been held by various high courts and the Honorable Supreme Court is this, that a revision cannot be dismissed for default or cannot be dismissed for non-prosecution. Unlike an appeal, where under Order 41 Rule 17 of the Code of Civil Procedure, an appeal cannot be decided on the merits of the matter if the advocate for the appellant doesn't appear to argue the matter. It has to be only dismissed for non-prosecution. But unlike that, a revision, it is held, cannot be dismissed for non-prosecution. The judgment in the case of Ramesh Chand versus Uganti Devi, reported in 2007, volume 15 SEC, page 384, has pointed out this proposition of law. Subject to any other contrary decision pointing out a different proposition of law, all of you can make use of this judgment. Now, we have also seen in our experiences that the High Court, while deciding the revisions, would hear the arguments and then feel that, yes, this is not a case for interference, and therefore it would simply say dismissed. Now, the Honorable Supreme Court, long back in the year 1996, in the case decided in the matter of Fauja Singh versus Jaspal Kaur, reported in 1996, volume 4 SEC, page 461, has held that a one word dismissed is not proper, is not appropriate. Reasons have to be recorded even when a revision is being dismissed. Now, the third final aspect is a revision cannot be allowed without issuing notice to the opponent. Of course, this is quite a fundamental thing for all the advocates, but still, we have a decision of the Honorable Supreme Court which has emphasized this also, that a revision could not have been allowed without notice to the opponent. You all can refer to the judgment reported in 2006, volume 7 SCC, page 800, in the case of Suresh Chandra Nanoria versus Rajendra Rajak. Now, there is one more experience that we all have. We come up before the Honorable High Court challenging an order in a revision where the order passed is on one particular ground. However, the High Court finds that after overturning such a finding on that particular point, the High Court will proceed to look into the other aspects of the matter, other issues in the case, and decide the entire dispute on the other aspects which were not subject matter of the discussion before the trial court itself, while passing the order impugned. So the Honorable Supreme Court, in the case of Jawlal versus Mohanlal, reported in 2013, volume 9, SCC, page 446, has held that in revision, only the ground on which order impugned was passed can be looked into. Deciding the whole suit by itself, when trial court had dismissed the suit only on the ground of court fees or valuation, is not proper. So, my dear friends, it becomes again our duty to present it before the courts. If the courts want to exercise jurisdiction under 115 of CPC and want to travel beyond the grounds or the issues which were decided by the court, which is the order of which is impugned, then we may use this judgment of the Honorable Supreme Court and highlight this point of law. Now, it is also another fundamental aspect that a revision lies only when there is no appeal anywhere. However, in the case of Kaushik Mutually Aided Cooperative Housing Society versus Amina Begum, reported in 2023 SCC Online SC, page 1662, this is reiterated, saying that when express appeal is permissible in law, revision cannot be filed, bypassing that appellate remedy. We have similar such judgments which have emphasized finer aspects of the exercise of revisional jurisdiction. These are only few which I found would be important and relevant for the purpose of our discussion today. Now, the proviso to Section 115, I had read to you earlier, makes it mandatory that unless the order, if it is challenged in revision, and when the revision is allowed, unless that would amount to finally disposing the entire suit or proceeding, no interlocutory order could be challenged in a revision under Section 115 of the Code of Civil Procedure. There have been various opinions of various high courts while interpreting this proviso, which has been added to the Code of Civil Procedure from 1/7/2002. However, this is a very, very important proviso because, as I said earlier, there were cases where any order passed at an interlocutory stage, an interim order passed at an interlocutory stage by the trial court, which did not substantially affect the rights or obligations of the parties at that stage, were subjected to revision before the high courts, and therefore such experiences led the legislature to take note of such anomaly and clarify the purport, the intent, the spirit of the provisions of Section 115, and that made the legislature to add this proviso with effect from 1/7/2002. The earliest of the judgments of the Honorable Supreme Court is in the case of Vidyodaya Trust versus Mohan Prasad, reported in 2006, volume 7, SCC, page 452, where it is held that revision lies against such orders. Had the revision been allowed, the suit would be finally disposed of. Now, here we have certain difficulties where we come across, say, an interlocutory application for grant of a temporary injunction filed under Order 39, Rule 1 or 2 of the Code of Civil Procedure in a pending suit. That application is disposed of either ways. Either it is allowed or rejected. And we take such an order in an appeal under the provisions of Order 43 of the Code of Civil Procedure. So that is a miscellaneous appeal against an interlocutory order. Whether the disposal of such an appeal either ways, or the disposal of an interim, passing of an interim order in such an appeal, which affects the rights of either of the parties at that particular stage, whether that can be subjected to a revision under Section 115 is another question which we all can ask to ourselves. However, this has been decided finally by various high courts. Yet, before it was decided finally, this was an anomaly where advocates presented such line of argument, saying that, see, if the order passed by the appellate court under Order 43 is allowed in a revision, then the entire application under 39 Rule 1 and 2 filed before the trial court would come to an end. So a proceeding would finally be disposed of, and therefore a revision would lie. However, there have been opinions which have held that a revision under such circumstances would not lie, and therefore there was a decision of the Honorable Supreme Court, which has subsequently been a subject matter of a discussion again recently. But then that decision in the case of Surya versus Ram holds that yes, merely because there is a proviso added to Section 115 barring revisions against interlocutory orders, the power of the High Court to exercise jurisdiction under Article 227 of the Constitution of India is not forfeited. Such power under Article 227 is the power of superintendence of the High Court over all subordinate courts and tribunals in the state. However, this has been subject matter of, again, another recent decision in the case of Radhesham, which is another topic altogether. We shall not deliberate more on that. But then it is to be understood that if we have to file a revision, if we have to choose the remedy of a revision, we need to understand that the order or the proceeding should be either a final order or a proceeding which finally disposes the entire case, or if it is an interlocutory order. If the revision is allowed in favor of the party challenging such interlocutory order, then by allowing of such revision, the entire suit or the proceeding should be finally disposed of. Only when this condition is fulfilled, a revision would lie. Otherwise, it would not lie. Similar view was taken much earlier also by the Honorable Supreme Court, where it held that yes, if while deciding as to what is the meaning of the word case decided, it held that yes, at interlocutory stages, it is possible that there may be a case where at an interlocutory stage, some issue is decided, and if that issue goes in favor of the party challenging it in the revision, then the entire suit would be disposed of, as sometimes say the suit is not maintainable or something of that sort. There have also been judgments where discussions have been as to whether a revision would lie when an application be filed in the execution case under Order 21 of the Code of Civil Procedure is decided, and there are provisions under Order 21 like Rule 98 to Rule 103, which say that certain of the applications filed before the executing court would amount to a decree by itself. And therefore, only an appeal under Section 96 would lie against such orders, or a revision would lie or not. This was a discussion in few judgments where the courts hold that if the decision on the application may not finally decide the entire dispute that is raised in the application, and therefore such a decision would not amount to a decree. And in such circumstances, whether a revision lies or not is a subject matter of such decision. So these are the finer aspects of the provision which we all need to know. In one case, in the case of Harishankar versus Rao Girdharilal, a judgment reported in AIR 1963, Supreme Court at page 698. What is held is that the scope of revision under the provision of Section 115 of the Code of Civil Procedure is limited to the grounds of error of jurisdiction. However, that may not be the only scope where there are revisions permitted under special enactments. For example, that was a case where the Delhi and Ajmer Land and Rent Act 1952 was in question. So the proceedings under that enactment were in question, and the court holds that yes, the scope there is different from the scope under Section 115 of the Code of Civil Procedure. The very same court, the very same judgment also has spoken about what is a jurisdictional error, and also another aspect which I will speak about a little later. Now we all know that the three essential conditions or the grounds on which a revision can be entertained are that A, where the jurisdiction vested in a court is not exercised by that court, or a jurisdiction which is not vested is exercised by that court, or the jurisdiction is exercised illegally or which has materially affected the rights of the parties. Now, the Honorable Supreme Court in the case of Mahabir versus Aviation, reported in 1999, Volume 1 SCC, page 37, has held this. while it may be true that there is an error of jurisdiction in the order impugned, yet the High Court will not interfere unless there is a consequent failure of justice occasioned or irreparable injury caused. So, my dear friends, we should all remember this, that there may be a minor error of jurisdiction exercised by the trial court, but reading the provisions of section 115 with the provisions of section 21 and 24 of the Code of Civil Procedure, 21 of the Code of Civil Procedure, unless we are able to establish that there is a consequent failure of justice occasioned or irreparable injury caused, the revision need not be, the power of revision need not be exercised, interference need not be shown. Now, this is what has been held in the judgment in the case of Mahabir, reported in 1999, volume 1, SCC, page 37. Now, we all must remember that the scope of revision is very limited to the grounds enshrined under the provisions of 115, or the scope of revision is also limited to the grounds which are stated in special enactments. But then we many a times misunderstand and read the provisions of permitting a party to file an appeal and the provision of permitting a party to file a revision as one and the same. The Supreme Court has held that appeal and revision are two different jurisdictions, and the distinction between the two is real. It holds that appeal is a continuation of the suit itself, and therefore what happens in an appeal is rehearing of the entire case. That is, all the facts, the points of law, everything is reheard in an appeal, unless the very provision which permits an appeal conditions the powers of the appellate court with certain exceptions. For example, a second appeal under the provisions of section 100 of the Code of Civil Procedure, though it is an appeal, but it is conditioned with a mandate that unless there is a substantial question of law, no interference can be made under section 100. So, accepting such situations, an appeal is a rehearing of the entire suit itself, and therefore it is a continuation of the suit. Whereas a revision is an exercise of jurisdiction by the superior court only on three grounds, which are mentioned in section 115, which ultimately take care of the errors of jurisdiction only. So this is the distinction between the two aspects, the two jurisdictions. In a revision, factual findings of the courts cannot be set aside or interfered with unless there is shown to be a fallacy of jurisdiction, which materially has affected the decision and the finding of the trial court on those facts and has occasioned irreparable injury or failure of justice to the party. Now, this is again the very same judgment which I referred earlier in the case of Shankar versus Rao Gurbachand Lal Chowdhury, reported in AIR 1963, Supreme Court 698. My dear friends, there are many other decisions which reiterate such position of law. However, it would be only repetition of the material, and this is the broader aspect of the law relating to appeals revision and its distinction with the provisions of appeal. As I was trying to tell you, though this is another topic altogether, the power of superintendence of the High Court under Article 227. However, for the purpose of this topic, what I had to re-emphasize once again is that the High Court's power of superintendence under Article 227 is not forfeited by the finality given to the revision, where in few states I mentioned that there is a revision before the district court, say up to the valuation of 5 lakhs. In Uttar Pradesh, it was 5 lakhs and is now enhanced to 25 lakhs, I believe. In Madhya Pradesh, it is 5 lakhs. In Orissa, it was earlier 1 lakh, where the district courts will exercise the jurisdiction of revision under section 115. Now, there such revisional judgment attains finality. So merely because it attains finality, it is not true that the High Court will not have jurisdiction to interfere at all. It may still interfere under Article 227 of the Constitution of India, exercising its power of superintendence over the subordinate tribunals in the state. Therefore, I may say in conclusion that it is to be understood, as I was earlier discussing also, it is to be understood that law is an ever-evolving process and the churning should happen, especially for availing justice to the parties. That's what I was emphasizing even in the earlier part of my lecture. I would now end this slide. I have ended my lecture so far as what I feel was relevant to be shared with you all people within the small time limit that was given to me.
Thank you, Mr. Amit.
Yes, sir.
We thoroughly enjoyed the session. And I hope once we share the slides on our YouTube channel,
I may only request, sir, if there is any error in my understanding of the law or in not laying my hands on the latest or the proper judgments, the audience may please pardon me. Maybe my research may be a little fallacious. You all shall also continue that research and take care of the correct proposition of law.
We all keep on learning from each other. And that's why we find that judgments also evolve with time. They say nothing is permanent except the change. So thank you, Mr. Amit Deshpande, for sharing your insightful session. We are always thankful for you and Trikram for sharing your knowledge on this platform. Thank you, everyone. Stay safe, stay blessed. Namaskar.